Every day in the USA, people find themselves in court.
This is in the District Court of Butler County, Kansas, case entitled State of Kansas versus Kyle Allen Chavez Majors. It's case number 2025 CR 46. Defendant appears from the Butler County Detention Center's Zoom location. Chris Pate appears as defense counsel. Brett Sweeney on behalf of the state of Kansas. This matter comes before the court at this time for sentencing. Docket notes indicate that this defendant appeared before the court on May the 12th of 2025. At that time, he pled guilty to count 1, possession of methamphetamine, a level 5 drug felony. Other charges were dismissed pursuant to a plea agreement. A pre-sentence report was ordered and sentencing set for today. Court has received a pre-sentence investigation report compiled by Sarah Wheeler, pre-sentence investigator, who is present on this meeting with us. I trust each attorney has received a copy of this report, and I'll ask the state's attorney first. Is there any objection to the criminal history which is stated in this report?
No, Your Honor.
Is there any objection by the defense, Mr. Pate?
No objection to criminal history A, Your Honor.
Very well. Court will adopt the criminal history as stated in the report and finds that the criminal history score applicable to today's sentencing is criminal history score A, and the court will proceed further accordingly. All right, I'll ask Mr. Sweeney, do you know of any legal reason why sentence should not be pronounced in the Chavez Majors case here today?
No, Your Honor.
Mr. Pate, are you aware of any such legal reason?
No, Your Honor.
Mr. Chavez Majors, are you aware of a legal reason or any other good reason why the court shouldn't proceed further with your sentencing?
No, Your Honor.
The court notes that there has been a motion for a departure sentence filed in the case. It is entitled Motion for Downward Departure, filed by the defense on July 14 of 2025. Court does have a copy of that motion before it. You may proceed further in regards to that motion, Mr. Pate.
Thank you, Your Honor. As everyone is aware from the PSI, this places Ms. Chavez Majors in the 5A grid box on the drug grid, which is presumptive prison with a sentencing range of 37 to 42 months. He was not Senate bill eligible due to one of his prior person felony convictions. We are asking the court to consider granting a dispositional departure to community corrections. In this matter, I think I pretty fully set out the reasons for that in the motion. Mr. Chavez Majors went to the trouble of and expense of getting a substance abuse evaluation done with South Central Mental Health while in custody. I emailed a copy of that to the court and counsel along with some other materials. Obviously, he's in custody, so his mom had to pay the fee for that, but that was something that they independently, with the help of my office, arranged. We've got a pretty thorough evaluation that recommends inpatient treatment, followed by aftercare, and then Mr. Chavez Majors' intent would be to go to a sober living facility after he's released. So he does have a concrete plan in place. It's obviously a little tricky to get a bed date when we don't know if a person's going to be released or when they are going to be released, but I think he would be willing to stay in jail until there was a bed available, if that was something that made the court more comfortable with granting a departure motion. As the court can see from the evaluation, Mr. Chavez Majors has a pretty severe drug issue that needs to be addressed. To that end, he has also been in custody for an extensive period of time. I show that as 166 days by the PSI, so we're looking at about a 6-month period of forced sobriety, which I think has been very good for him. And in my observations of Mr. Chavez Majors, just talking with him at the beginning of the case, the middle of the case, and the end of the case, his mindset has seemed to improve as this has gone on and as he's distanced himself from methamphetamine. He by my observation, is in a much better and more clear state of mind now than he was at the beginning of the case. I also, in those materials I sent into court and counsel, attached, I think it was about a 7-page transcript from the eDovo online learning platform that's available to inmates in the jail. This is something I don't even think I was aware was available to inmates until I started working with Mr. Chavez Majors. He's completed 151 hours of education in various different programs online, and that transcript details all of that. As we all know, when people are in jail, they say, well, I want to do this and this and the other, but I couldn't do it because I was in jail. And there were a lot of things Mr. Chavez Majors would have liked to have done, such as already start treatment, find a job, get into a sober living facility, things he couldn't do. But unlike a lot of people we see, he's taken control over things he could do, and he completed this programming that I've provided to the court. So that's pretty significant to me. So I think Mr. Chavez Majors has used his incarceration to the best of his ability to try to better himself and also demonstrate to the court and the community that he's serious about getting things right. He's also got some pretty good job skills. He had previously worked at Coke Industry I think he's got a welding certificate, so he's capable of earning a pretty good living, and he has in the past. He's identified JD Engineering in Augusta, which I think is a subcontractor that different aircraft industries around Wichita use, identified that as a possible place where he may try to gain employment once he's out in the community. And I've just through my dealing with Mr. Chavez Majors, he's got some criminal history. He's indicated to me he's done. He's ready to change his life. This is not the lifestyle he wants to continue living. He's ready to make those changes and better his life. And to the extent he's been able to while he's in jail, I think he's done everything he could possibly do to better himself and show everyone that that's what he's serious about doing. So formally, our recommendation would be that the court impose a 40-month prison sentence with 20% good time and 12 months post-release. We are asking the court grant a dispositional departure, place Mr. Chavez Majors on community corrections for a period of 12 months with the conditions that are set forth in the PSI. We would be very open to Mr. Chavez remaining in jail until there is a bed available, if there's a good way to do that, so he can go directly from jail to inpatient treatment to ensure that his sobriety stays intact. And I believe those would be all of my sentencing recommendations, Your Honor.
All right, Mr. Pate, through your argument to the court, you've obviously diligently advocated on behalf of your client, but what the court wishes to address with you is Mr. Chavez Majors has 2 prior drug cases and 3 prior alcohol violation cases. And through all of those cases, he's had an opportunity for substance abuse treatment and most likely orders along those lines, and to achieve ultimate behavior modification. But through all of these cases, he has not changed his behavior. He's still involved with a very serious street drug, methamphetamine. So what would be different now? I mean, you say that he finally gets it and that he's willing to do all of these things that he's never been willing to do before. So what's different now, Mr. Pate?
Well, and Your Honor, I believe due to other cases that occurred around the time he did not fully get the chance to complete Senate bill out of that Greenwood County drug case in 2015. So I think it may have been ordered in 2015, but then there was I think there was a violation or another case that got him sent to prison before that could actually be completed.
And that's a valid excuse then? That he committed a person felony that got him sent to prison and therefore he couldn't complete treatment?
Well, and Your Honor, as I said, he's taken every concrete step he could now. We're looking at these drug cases that occurred a decade or more ago. He would have been 21 at the time. He's 31. I think he's got a much different perspective on life that he did at that age. He was an adult, but as we all know, people sometimes in their late teens and early 20s may be an adult by age, but they don't make adult decisions. I think he's got a different perspective. I think he's spent some time in prison and realizes that's not the route he wants to go. He fell back into the trappings of drug addiction when he got picked up with this case. And that's not the life he wants to live.
Thank you, Mr. Pate. Mr. Sweeney, on behalf of the state, do you have any response argument that you wish to make to the motion for a departure sentence?
Just very briefly, Your Honor, part of the plea agreement obviously was that the state was free to argue for the presumption in this case, and the presumption is obviously prison, so the state will argue for that and against the departure motion. I don't know that I have a lot to offer. Obviously, I think possession of methamphetamine is pretty self-explanatory on its face. But obviously Mr. Chavez Majors does have some significant criminal history. That's evidenced in the PSI. And as far as new perspectives or change perspective goes, he's done some time in prison. And I guess one would have thought that maybe that prison time would have changed his perspective enough to not get in trouble again and not end up back in front of the court. I think, the legislative intent is, and the criminal history is what it is. And so I won't make more of it than that. The state's asking for the court to follow the presumption. Mid-box standard 40 months, corresponding good time percentages, and post-release supervision durations. State's not requesting a fine. We would ask the court to impose attorney's fees if necessary. And there was a KBI lab fee that was completed, and would also note that he does have the 166 days of jail time credit. I think that's appropriate. I don't know that I have a whole lot more to offer beyond that, Your Honor.
All right. Thank you, Mr. Sweeney. And implicit in your argument regarding the departure were your sentencing recommendations. I did want to make sure that you have completed your sentencing recommendations to the court. Is that correct, Mr. Sweeney?
That's accurate, Your Honor.
All right. All right. I will ask if there's any victim or members of a victim's family who desires to address the court in relation to this sentencing, though it appears that no such persons are on this meeting. At this time, then, I'm going to ask for formal recommendations from Mr. Pate regarding an appropriate sentence for Mr. Chavez Majors.
Thank you, Your Honor. And I think I made most of my recommendations formally. We're asking the court impose the standard number of 40 months with 20% good time and 12 months post-release. We are asking the court grant a dispositional departure to 12 months of community corrections probation. We would be open to a jail sanction or something of that nature that would keep Mr. Chavez Majors in jail until an inpatient treatment bed was available. In the alternative, if the court does not think probation is appropriate, we would ask the court consider a durational departure.
Very well, Mr. Pate. Thank you. I want to ask you how much your fees were in the representation of this client.
Your Honor, they're going to be approximately $1,000.
Thank you. This time, the court will address the defendant, Kyle Allen Chavez Majors, personally, and I'll ask him if he has any statements that he wishes to make in mitigation of punishment or anything further that he personally would like to present to the court. Mr. Chavez Majors?
Yes, Your Honor. As far as I I had a lot of sober time from that first possession case. I was first given an illegal sentence, and I had a motorcycle accident, which I was drinking and I hurt somebody. And the way that the sentence worked is that was my controlling sentence, and they ran the Senate bill, which I got later. At the same time, I was never able to actually even go on probation or do the treatment. And from 2015 until 2023, I was off of drugs. After I got off parole, I got in trouble again from drinking. And last year, I'm not trying to make any excuses, but I had my father and my sister both died within a month of each other. And I didn't take it very well. And I fell back into using meth. And it's an addiction. It took me over. And I wrote something that I'd like to address the court with. I would like to respectfully ask that the court show mercy on me when making your decision for my sentence. I don't take this situation lightly, and I understand that my actions brought about the charges I'm faced with today. I hold myself accountable, and I'm not ashamed to admit that I needed help. On February 2nd, 2025, God answered my prayers and the prayers of my loved ones. I was deep in a drug addiction, starving and malnourished, and I was losing my mind. My kidneys were failing, and getting arrested may have very well saved my life. Today, I'm 5.5 months clean and sober, and I've been consuming a lot of valuable information on life, spirituality, sobriety, and business. Having earned over 50 certificates and completing my new and updated resume, I have researched potential employment opportunities, and I developed a detailed plan for if the court grants my request for probation. I have with me my written plan and goals and my resume and my list of potential employers, if you would like me to share any further. Thank you.
You have a list of possible future employers?
Yes, sir.
Okay, who's on this list?
I have Textron Aviation. I have Valmont, AA Corp, Coperion, FIR Delivery, Terrytown Expo Care Delivery, Manpower, Stanley Black & Decker, and JD Engineering. I have my plan made out for if you're to grant me probation. I would go to do the inpatient treatment, complete the drug treatment. While I'm in treatment, I'd submit resumes and applications to all the employers that I've researched. I would be submitting applications to Oxford and sober living houses. I'd continue to maintain my sobriety and attend required AA, NA, and meetings in compliance with sober living and court. I would maintain employment and make my payments on any and all court fines and probation fees. I will successfully complete probation, having cut off all people, places, and things that might cause me to backslide into addiction. I would continue a healthy lifestyle and sobriety with family and church, having gotten in touch with God, back in touch with God and my spiritual side.
All right. Anything else, sir?
Just basically, I got bullet points of my goals, but that kind of went over most of it.
All right. Very well. Thank you for your statement, Mr. Chavez Majors. Court will pronounce sentence in this case at this time. Court hereby establishes count 1 as the base sentence in this case for the offense of possession of methamphetamine, a severity level 5, non-person drug felony, in which the defendant has a criminal history score of A, thus placing him in grid box 5, drug A. The court hereby sentences the defendant to a term of 37 months in the custody of the Secretary of Corrections of the state of Kansas. On this sentence, the defendant may earn up to 20% of good time credit and would be subject to 12 months of post-release supervision. Court has considered but declines to impose a fine in this particular case. Court has considered the motion for downward departure. After all, in grid box 5, drug A, this defendant falls in a presumptive prison box. The court does not find substantial and compelling reasons to grant a departure in this case. Based on the entirety of what's been presented to the court and what's been presented to the court through paperwork, court finds that there just is no substantial and compelling reason here for the court not to follow the statutory presumption of prison in this case. The court does order that the defendant complete the remainder of the 37-month prison sentence which the court has imposed. Or does grant the defendant 166 days of jail time credit that he's already served in this particular case against that sentence. The court will be assessing a $400 restitution amount to the KBI laboratory and will be assessing a felony docket fee to the defendant. All bids amounts are waived in this case due to the court's incarceration order. The court will advise the defendant that at some point in the future he may have the right to seek expungement of this offense. Certain statutory limitations do apply. If the defendant has any question about his right to someday seek expungement, he can address those questions to a lawyer and I'm sure get your questions answered. The court at this time advises the defendant that under certain limited circumstances, a criminal defendant may have the right to appeal their conviction to an appellate court having jurisdiction. And if they are unable to pay the cost of an appeal, the defendant may request the court to appoint a lawyer to represent them on appeal and that they be supplied with a transcript of trial court proceedings. Pursuant to KSA 22-3608C, the defendant has 14 days after this judgment to file any notice of appeal with the clerk of the district court of Butler County, Kansas. The defendant does have the right to appeal this sentence if the court has ruled adversely to him at this hearing. I will remind Mr. Chavez Majors that there are prohibitions against a convicted felon possessing a firearm, and that there are losses of certain civil rights, such as the right to vote, until his sentence is fully discharged. I will note for the record that the court has, to some extent, considered the recommendation of one of the arresting officers that Mr. Chavez Major be prosecuted to the full extent of the law. The court further finds that the defendant has had multiple opportunities to seek exactly the type of sober living that he advocated to the court today and has elected not to. Mr. Chavez Majors, you knew when you were out in the community after serving your prison time that you're in the A box. Therefore, any felony offense would put you in a presumptive prison category. Yet, you say due to addiction, you made a decision, regardless of how it was compelled, to take a chance. You knew that any possession of a serious street drug like methamphetamine, fentanyl, or other types of drugs like that was going to result to you being essentially in a prison situation, but you were willing to take that risk. And unfortunately, you were caught, effectively prosecuted, and now you've been sentenced. The court has granted you, in this case, a mitigated sentence because the court does want to give credit to some degree for some of the coursework and efforts toward education and rehabilitation that you have made while locked up. I highly encourage you to take advantage of any Department of Corrections programs along those lines, which may exist, so that when you do get out and get released, hopefully with a full amount of good time credit that you've earned, to shorten your sentence to the earliest possible date of release, that at that point you're truly in a position to be successful in the community and not be involved with drugs ever again. Good luck in that regard, Mr. Chavez Majors. I think that's a goal that I hope someday you actually achieve. All right, Mr. Sweeney, I'm going to ask you, are you aware of any other sentencing related matters which the court needs to address?
No, Your Honor.
Mr. Pate, are you aware of anything further that needs to be addressed here?
Did the court also consider a request for a durational departure?
That request, obviously based on the announced sentence, has been denied by the court.
Nothing
I realize
further.
this was .002. They scraped stuff out of a pipe and said it was possession. This is
Court's not going to review again the facts and circumstances of the case?
It just offered my cellie, who had a pound of meth, probation yesterday.
All right, the court remands the custody of Kyle Allen Chavez Majors to the Butler County Sheriff's Office until his custody can be transferred to the Department of Corrections to serve the remaining balance of the mitigated sentence which the court has imposed here today.
This will work. This will work. Send me back to prison. My daughter's
There's
13
nothing
years
further.
old now. This will work.
If there's nothing further,
Con
the Chavez
college.
Majors matter will currently be in recess, and this meeting may be